First District Court of Appeals now in session. All who have business before this court draw near, give attention, you shall be heard. May God save these United States, the great state of Florida, and its honorable court.
Good morning. We have one case on the docket this morning, Antoine Salome versus the Florida Department of Health. Before we start the argument today, we remind counsel that by prior order of the court and pending a ruling by this court, the records in this case have been accorded confidential treatment under Rule 2.420 of the Florida Rules of General Practice and Judicial Administration. Counsel should not discuss the allegations contained in the administrative complaint, and this morning's argument will focus on the procedures employed by the respondent, the timing of filings and responses, and other procedural matters. Counsel, if you are ready, you may begin.
Yes, thank you, Your Honor. May it please the court. My name is Michael DeLugo from the law firm of Wicker Smith in Orlando, Florida. I represent Dr. Antoine Salome. If I may, I would like to reserve 3 minutes of rebuttal time. I understand that we have been allotted 15 per side.
That is correct and so noted.
Thank you. First, I want to thank the court. I've never had a case go from petition to oral argument in 10 days before. And so I do appreciate, on behalf of Dr. Salome, the court's expediting this entire process. What this case involves is the fact that the Florida Department of Health failed to follow the statutory mandate regarding how it handles investigations of healthcare providers in the state of Florida. This case was initiated with a complaint in June of 2020. Dr. Salome timely responded to that complaint in July of 2020 in a submission that included a request that the department provide Dr. Salome's counsel, my partner, with its investigative file prior to the presentation of the case to the probable cause panel. That did not happen. The case was presented to the probable cause panel without any of the materials that Dr. Salome had presented in his defense. And as might be expected, the panel, without any responsive evidence, found that there was probable cause. And that triggered the rendering all of the investigative file materials public and the administrative complaint public. So now any member of the public is able to obtain or access the administrative complaint against Dr. Salome, as well as all of the investigative file materials. And we feel that that is in violation of his due process rights. The Florida statute that applies to this is 456.073, and that statute contains certain directives that the Department of Health is required to follow in conducting investigations of healthcare providers in the state of Florida, and that did not happen here. The statute specifically states that the respondent to a complaint has the ability to present evidence in his defense, his or her defense, and that the evidence shall be considered by the probable cause panel. That did not happen here. The statute also provides that the materials that are included in the investigative file shall remain confidential until there is a finding of probable cause, and then 10 days after that. Well,
Counsel, if I could interrupt, I apologize. On that 10 days, I have a question or two. I think it's pretty clear the department has conceded this is a fairly gross violation of due process. There's a statutory obligation. It says they shall consider these materials. They did not, for whatever reason, we don't know, but they did not. And they've conceded that it's a due process violation, I believe. They can correct me if I'm mistaken on it. The question I have is, there seems to be a discrepancy about calculation of dates here. They appear to take the position, at least implicitly, that the 10 days runs consecutively, meaning it's not business days, it's calendar days, even if there's holidays in between. And you seem to calculate it differently because they disclosed the complaint on Monday the 5th. You and your pleading say that the first date they could have disclosed it was Friday the 9th. What calculation rules were you using?
I was using I was counting the 10 days from the date that Dr. Salome was provided notice that there had been a finding of probable cause. So there was a gap of 4 days between the March 25th finding of probable cause and the March 30, which is the date on which Dr. Salome received notice that there had been a finding of probable cause and actually received the administrative complaint. I think due process requires the 10 days to run from the time that the respondent is made aware of the actual finding of probable cause, because if that were not the case, then the probable cause panel could find probable cause, and then there could be a delay of weeks before the respondent is made aware of that finding. And so I think due process requires that we count the 10 days from the date on which the respondent actually is provided notice of that finding. I don't believe that happened here because my understanding and my reading of the department's response to our petition was that by the time that response was served on Wednesday of last week, that the materials had already been made public, and that was April 7th. So they may have been counting from the 25th of March. I was counting from the 30th. Regardless, we're here on April 12th, and we're past the 10 days, regardless of how you count them.
I'm a little unclear on why there was 5 days between the complaint being filed and you receiving it or your client receiving it. It's a 10-day period before it becomes public record, and 5 of those days looks like it was in the mail, or I don't know what was going on.
That's correct, Your Honor. I believe we have the U.S. Postal Service to thank for that 5-day gap. The materials were not provided electronically; they were sent by a regular mail, I believe.
And within 24, 48 hours, it looks like you put the department on notice that there's a problem here. They acknowledged there's a problem, yet they refused to withdraw the complaint.
That's correct.
Or I'm sorry, they refused to not disclose the complaint. It had not been put on a public website at that point.
Correct. So it is public, right as we speak right now. It is available to the public. Dr. Salome received notice on March 30th of this year. We contacted the Department of Health on April 1st, and we filed our petition for writ of mandamus on April the 2nd.
Okay, thank you.
Well, counsel, I'd like to turn your attention to 2 statutory provisions dealing with timing, because neither of them mention, when the complaint is received or when notice is provided. Those provisions simply say 10 days after probable cause has been found to exist. And so it's not even tied to the administrative complaint filing. It's really tied to that probable cause determination that occurred on March 23rd. The 10th day after that would have been April 2nd. Is there any other statute or rule that you're relying on to tie notice to the statute to require, receipt of the complaint or receipt of information about the probable cause determination?
No, Your Honor. I'm relying entirely on the one statute that I've cited in the petition, and in making a legal argument based upon the application of due process to the language of the statute.
Okay, you've selected mandamus as the vehicle to seek relief in this case. And again, I think that the department will and has conceded due process violation by the probable cause panel. What is the clear legal right here that your client is seeking? Is it to withdraw the complaint? Is it to take the complaint out of the public domain? What precisely is the remedy, and from where does that arise?
What the remedy that we're seeking is, and I apologize if the Latin phrase makes sense here, status quo ante. So Dr. Salome had certain rights with regard to the maintenance of the confidentiality of the contents of this investigative file until such time as the case was presented to the probable cause panel. But those due process rights are only protected if the due process or the probable cause panel actually considers the materials that were submitted on behalf of Dr. Salome. And so because that procedure was not followed in this case, the relief that we're seeking and the clear legal right that Dr. Salome has that has been violated is that he has a right, and this is contained explicitly within the statute, he has a right to all of these materials to remain confidential until such time as the probable cause panel appropriately considers both sides of the story. And so I selected mandamus. I struggled with the precise method of relief. I'm also recognizing that we were under some time pressure. I selected mandamus because I felt that relief was the most closely approximated what we were seeking here, that Dr. Salome had a clear legal right that these documents remain confidential until the proper procedures were followed. And those were not followed in this case. And so the remedy that we're seeking is that all of these materials in the investigative file and the administrative complaint itself should be withdrawn from the public domain until such time that the probable cause panel reconvenes and reconsiders their decision, including all of the materials submitted on behalf of Dr. Salome.
Why wasn't this our petition rendered moot on Monday morning when the complaint was first posted to the DOH website? And I mention that because The petition filed in this case was filed on Friday, April 2nd at 5:23 p.m. after normal business hours. It was not docketed in this court until after 9 o'clock on Monday morning, by which time the complaint had been, had been disclosed by the Department of Health. And our records indicate from, our IDCA portal that the notice through the court was provided around 9:37 a.m. Again, about an hour and a half after the complaint became public. Is there any indication that the department was made aware of the petition prior to Monday morning at 8 o'clock?
No, Your Honor. I know that the petition was filed after 5 o'clock on Friday afternoon. We moved with all deliberate speed. I promise you, we did everything we could to get this petition filed as quickly as possible after learning of the situation. I personally didn't learn of this until April 1st, which was Thursday, and the petition was drafted and researched and filed by after 5 o'clock on Friday. So according to the rules of judicial administration, I guess the court deems that document to have been filed. My understanding is that with electronic filing, that even if it's filed after 5 o'clock, it's still deemed filed on April 2nd, as opposed to the older rules prior to electronic filing, in which if you filed something after 5 o'clock, it was deemed filed the next business day. But be that as it may, as far as whether this was rendered moot by the release of the administrative complaint, this is not just a cat out of the bag situation. This is an ongoing due process violation. So Dr. Salome is being harmed even as we speak. And so, no, I do not believe it was rendered moot by the release of the administrative complaint, because every minute that this document and this investigative file is available to the public, Dr. Salome is harmed. And so the relief that we're requesting is to stop that from happening until such time as the Department of Health and the probable cause panel follow what the requirements of Florida law.
And from the filings in this court, that rehearing or reconsideration will convene this Wednesday, April 14th. Is that correct?
That is correct. We were not aware of that as of the date of filing of the petition, which was on April 2nd. At that time, we had been told that the matter would be presented to the next scheduled probable cause panel, which would take place either in May or in June of this year. And then we learned sometime last week that, in fact, a special probable cause panel will be convened on Wednesday, April the 14th, 2 days from now, to reconsider the probable cause determination.
Thank you.
Counsel, like Judge Rowe, I guess my concern here is that the statute seems to provide that when you're in a situation like this, that the probable cause may be reconsidered, or probable cause, ultimately the department may not go forward on the probable cause determination. But I don't see an avenue for withdrawing either a probable cause in this intervening period before the rehearing, or withdrawing an administrative complaint. Am I correct? There's nothing in the statute about it. It's more of an equitable oriented argument.
It is, but it's based on the fact that the department violated the plain language of the statute. And so we're really left with, very few options as far as how to remedy the situation as it currently exists. And so even if we're only talking about a period of 48 hours, that's still 48 hours during which Dr. Salome's due process rights are being violated. And so we would ask that any of the materials that are currently available to the general public through the Department of Health's website, or through any other domain that the Department of Health controls, that those materials be withdrawn and held out of the public domain until such time as Dr. Salome's rights have been properly considered.
Counsel, if I could follow up, I imagine the presiding judge here, Judge Rowe, Judge Rowe will give you extra time, but when you filed the petition, did you call opposing counsel? Did you email them? Was it served in some way or just thrown in the mail? I mean, how did you put the department on notice that, other than you obviously you sent a letter to them, you told them not to disclose the complaint in a letter and an email to them and so forth. Once you filed the petition, what did you do to let them know that this is out there and been filed?
I believe that we notified the department on April 1st that we were planning on filing a petition, so we told them ahead of time that this was coming. I don't believe that my office sent an electronic copy directly to council. I could be wrong about that, but I don't want to misrepresent how they were notified. Generally, we rely on the e-filing system to provide notice. And so my understanding is that there would have been an electronic notice that something had been filed, but I did not personally send a courtesy copy directly to council for the department.
All right, thank you.
Well, I see I have 40 seconds left, so I'm going to reserve my remaining time for rebuttal, unless the panel has any further questions.
Yeah, thank you, counsel. I'll extend your time by 2 minutes, and I'll also extend the time for the respondent as well by 2 minutes.
Thank you.
You're welcome. Counsel, you may proceed.
Good morning. May it please the court. My name is Sarah Young Hodges, and I represent the Department of Health in this matter. The department concedes that it erred in failing to provide the responsive documents to the probable cause panel before that panel convened and found there was probable cause. And the department is doing everything that it can within its lawful authority to correct this error. That is why we asked the board to schedule a special probable cause rehearing for this Wednesday, about 10 days after the petition was filed, so that we could correct this error as quickly as possible.
Well, let me ask you this. You said the department did everything it possibly could. I mean, the department knew to a certainty that there'd been a due process violation. I mean, a serious due process violation. You're dealing with people's professional reputations here. And this doctor didn't have his affidavit considered. So you knew that there's another side to the story, right? And the probable cause panel didn't get to hear that other side of the story, yet the department marched forward despite the protestations, despite the acknowledgement of the gross due process violation, and disclosed the administrative complaint. Is that the way the department operates?
The department has to operate that way based on the public record statute. Section 456.073 sub 10 provides that once probable cause is found, that the complaint and all other investigative documents, which also includes the administrative complaint, become public record.
Okay, so you find out from someone that actually the probable cause panel has found probable cause against someone that's the wrong person. You're going to still send out the administrative complaint, publicly make it, even though you know it's the wrong person?
The department looked into all of our governing statutes in this case to try to determine what would be the best avenue to proceed and still comply with those statutes that govern the department's actions. And the only provision that the legislature provided for the department to not proceed with prosecuting a complaint in which probable cause was found is to then send it to the board for them to decide whether to process or to prosecute the complaint themselves. But if we had done that, the next board meeting isn't for months. So we instead asked them to rehear the case at another probable cause panel, because that would be a much more timely way to remedy this situation.
Well, you say remedy, it does in fact give the doctor a chance to tell his side of the story. And it does remedy that, but it doesn't remedy the whole purpose of the statute, which is to have confidentiality in the process. I mean, if the probable cause panel now finds, you say it's a new probable cause, I assume it's three different people?
I believe so, but I can't see why it would be. It shouldn't be the same panel, and I will ensure that it's not when we get off this this oral argument.
I mean, they may indeed find no probable cause, and but then still, there's been, I would argue, substantial harm. Correct? I mean, someone has been had something publicly disclosed that shouldn't have been disclosed.
I would not disagree with you, Your Honor.
Okay. Well, and the other point, this proceeding had been initiated on Friday, and technically it was lodged with us on Friday, and it was an emergency matter, and the department was apprised of it. Is it the department's position that they could effectively disclose this administrative complaint, knowing that's the very remedy, perhaps the only remedy this court had, and take it away from this court to essentially take away our jurisdiction to provide relief here by simply rotely disclosing it within 10 days?
To clarify the timeline, as Judge Rowe pointed out, the probable cause was found the 23rd. 10 days from the 23rd was April 2nd. The petition was filed after business hours on Friday. Department counsel, I spoke with the 2 department counsel who were served with the petition. They received it 9 and 10 a.m. on the following Monday. So April 5th is when they saw it. It had been uploaded by the clerk's office at 8:06 a.m. that morning. So by the time the department was aware that the petition had been filed, the administrative complaint had already been uploaded by the clerk's office.
Well, I mean,
Counsel, I have a logistics question about how things work. Subsection 4 of the statute talks about the probable cause panel finding that probable cause exists and then directing the department to file a formal complaint. And then it says the department shall follow the directions of the probable cause panel. And I'm wondering, I didn't see in any of the appendices the directive from the probable cause panel to the department or any directions that that went to the department. And I was wondering what form do those directions take and whether there's anything in those directions about anything that's, egregiously out of whack or whatnot as communicate back to us if there's something, way problematic about the probable cause determination. Just what are the logistics and what did those directions look like?
That I do not know. I'm sorry, Judge, I can't answer that. I haven't seen a directive in any of the record of appeals I've had. I'm happy to follow up after this argument to see if there is one, if there's a written document rather than just the understanding that if the probable cause panel finds there is probable cause to proceed, the department has to then prosecute the case, which is what the statute provides. But I don't know if there's written documentation that's provided.
Yeah, that would be helpful because the statute seems to talk in terms of a directive and then directions. And so I'm interested in what that looks like.
Mm-hmm. Mm-hmm. I'm happy to see if I can find something like that.
As you have answered previously, the department's obligations with regard to disclosure are all tied to the probable cause finding. And again, going through the statute, there doesn't seem to be a specific authorization for the department to do anything other than, file the complaint and disclose the documents if probable cause has been found. But doesn't the probable cause panel itself have discretion to revoke its finding if there's a due process violation? Is there any reason why they could not have made a decision in the interim while they're considering or reconsidering Dr. Salome's response to do something different?
Under 456.073 sub 4, the way that the department has interpreted the statute, that once the probable cause panel finds that there's probable cause, that the authority to continue to prosecute the case is then with the department rather than the probable cause panel. So that was why I suppose it's somewhat analogous to when a licensee is appealing their discipline to the first, and then they ask if the board would rehear the case, and they ask the first to then relinquish jurisdiction back to the board to hear the case. That is, I think, analogous to what the situation is. So at this point, the department has asked the board to rehear the case rather than us proceeding with the prosecution. So the board has the probable cause panel has the jurisdiction to rehear it and decide again whether or not the department should continue the prosecution.
Would that be the same remedy, going back to Judge Makar's earlier question, if there had been, names had been transposed and they would have substituted, say, the Surgeon General for the subject of the complaint here, the process would have gone forward against the Surgeon General without any kind of communication back to the probable cause panel that there was a problem here?
Yes, the department, through its research, cannot seem to find another way to do this.
Well, wait, I mean, look, you're basically saying that the law is so inflexible as to allow gross violations of the statute, and the department has to sit on its hands and not do anything. I mean, what if the probable cause panel, a couple of days after they initiate probable cause, find probable cause, finds out, oh, I've got a conflict. I'm on probable cause. I should be on this panel. So it's infected the whole panel. It's a conflict of interest, and this never should have issued. It's just going to have to be sent out to the public. I just don't get it, how the department can possibly think that's the nature of their authority.
Based on the public records law, there doesn't appear to be wiggle room.
But Judge Osterhaus said, well, what about revoking? Why can't they just revoke the probable cause finding? That seems to be inherent authority. We've done something wrong. We should be able to revoke our action. It's a void action, essentially. What they did in this case is a void action. They did not comply with the statute, the most critical part of the statute in some sense. They just have to let it go. I don't get that.
Well, that's why the probable cause panel is rehearing it.
I know it is, but I'm talking, that's looking forward. I'm saying what they did in this case to date.
No, I understand. The department just has been, because of what subsection 4 provides, that one remedy, if probable cause is improvidently found, for us to go to the board and say we don't want to prosecute this case. And
well, there's obvious, I'm sorry to interrupt, but obviously we have limited time, but obviously you disclosed in this case on the 11th day. It's not a hard and fast rule. It's not 10 days. You did it on the 11th day here. So there is some flexibility the department has recognized. I don't understand why they don't recognize it in favor of someone whose rights have been severely violated versus an Easter holiday.
I'm sorry, Judge.
Well, you were required to disclose on Easter Sunday by your interpretation of the statute. You didn't do it.
We were, from what I understand from the clerk's office, I spoke with them Friday, that occasionally what happens is they begin the upload on the Friday, and that sometimes it takes a couple days for it to appear. So the 8:06 a.m. was when it appeared on the site. So so that is the process, is that it's 10 days is our hard and fast rule, but sometimes the system does not upload correctly, is what I was told. But it is 10 days. Unfortunately, there is not any sort of department directive or written policy that tells the clerk's office that this has to be done this date. They all just do it. They are now working on that. So I believe that is something that will be in place within the next couple months. I also wanted to call the court's attention to Florida Rule of Appellate Procedure 9.1000 sub H that states that the issuance of the order to show cause is what stays the proceedings. Here, the order to show cause was issued at 1:02 p.m. on April 5th. And the administrative complaint was uploaded, as we've stated, at 8:06 a.m. So the department has complied with the Florida appellate rules as well as its statutory obligations in this case.
Counsel, is the only remedy that a licensee has for this type of due process violation, is that found in 456.008, dealing with accountability to the governor and accountability when the board members act outside their statutory authority?
That would be a remedy. the department hadn't considered that as a remedy, that they were operating outside of their statutory authority, as this was the department's error, not the board's error. That's the other issue with the subsection 4 remedy, was that probable cause wasn't improvidently found based on something happening with the board. It was the department's error.
But didn't the board did not consider the response? That's the due process violation at the probable cause panel level, correct? And so that is the main violation that has driven this entire process. So if there is any remedy, is that remedy in 456-008?
I'm not sure, Judge Rowe. I'm sorry. I'm trying to think. I got my second COVID vaccine yesterday, and I'm not feeling quite 100%. I don't want to say that the board bears the liability for this. I think that it's the department that bears the liability for it.
All right, and let me just clarify that the mechanism for holding, if whoever's accountable, but the mechanism for holding the board accountable or the probable cause panel would be under that particular statutory provision, correct?
Correct.
Okay, thank you.
Mm-hmm. If the court has no further questions, then the department would ask that you deny this petition, as there is no legal right to the remedy that is sought. Thank you.
One final question for me, at least. If you had gotten the notice on Monday, and I say you, I'm talking about your client. If you'd gotten it from our court, and it was up, this administrative complaint was uploaded and ready to fire off as if it was a nuclear missile that can't be stopped, which to the physician it is. I mean, this is cataclysmic to someone's profession. Are you telling us today that the department couldn't stop? In other words, once you get the order from our court, we have a pending proceeding. The remedy sought is to not disclose it. Is the department has this system where it's just going to go off anyway?
That I don't know. If we had received the order to show cause on Friday, then it would not have been uploaded to the department's website. That I can say with full confidence.
Okay, so I guess the answer is yes, as long as whoever talks to whomever in the department, they connect.
Correct, because it is the clerk's office that does the uploading, not the attorneys that are involved in the case.
All right, thank you.
Mm-hmm. Thank you, Your Honors.
Thank you. Counsel for petitioner may proceed.
Thank you, Your Honor. We definitely take issue with the department's position that it has to act the way that it did. The due process violation in this case changes everything. They're not statutorily restrained from recognizing the due process violation and fixing it. Merely because there's nothing in the statute that says explicitly lays out what the department is supposed to do when there is a gross due process violation, doesn't mean that they can't do the right thing from an equitable perspective. If you follow the department's logic, even if when this case is represented on Wednesday, April the 14th, and the new probable cause panel finds that there is no probable cause, according to the department's interpretation of its statute, this material in the investigative file and the administrative complaint would still be available to the public. Because there's nothing in the statute that says that if there is a reconsideration by the probable cause panel and they find that they have improperly granted probable cause and they change their mind, there's nothing in the statute that says that they can go back and delete all of that material from the public domain. And so that cannot be the law. And if you follow the department's argument to its logical conclusion, that is what would occur. And so this remedy by writ of mandamus is, through the research that I did, is the only way that we could come up with as a means to restore Dr. Salome's rights in light of what has occurred in this case. And so we ask that this court grant the writ of mandamus and direct the department to remove the administrative complaint from its website and from any other public access, and more importantly, to also remove the contents of the investigative file itself from the public domain until such time as there is a proper consideration by the probable cause panel of both sides of the story. And unless the panel has anything further, I will rest on the contents of our written filings.
Thank you, counsel. Thank you both. This court will stand adjourned.